All right, you guys, we were able to get on a little bit early. I appreciate your patience. So I definitely, like I posted in the group, have Larissa here. Before we get started, as always, I want to express my appreciation for each one of you asking your questions, being a part of the group, inviting your friends to the group. It definitely doesn't go unnoticed, and it's definitely appreciated. If you haven't already, please like, subscribe to this video, subscribe to the YouTube channel, Money Talks. Obviously, that's broken down. There's extra videos on the channel to assist you in your wealth building journey. But yeah, I want to encourage you during this time because we're going to talk about something I don't typically talk a lot about, and that's around the protection of your assets for building wealth, or just that next step when you think about the generational wealth piece. This is how this plays out. This is going to be the most important piece to your generational wealth. I talk a lot about building your investments, budgeting, teaching your kids, and that's teaching your kids is definitely a form of generational wealth. But now we get into more of the tactical things to help you make sure that, hey, I got $2-3 million that I didn't worked hard for over a 20-year period. I don't want my kids to get themselves in trouble. So those are some of the things we want to discuss today. So yeah, I have Larissa here. Definitely a lovely young lady. She also actually has several different articles that I definitely I share one of them, but I'm definitely gonna go through and add the rest so you guys can read through it, because it's really good content, the way it's delivered, because it's easily digestible for a complex subject. But we're going to talk about the legal way you can protect your assets. So the most common way we mostly talk about is, hey, you need to get a will. Should I get a will? What qualifies me for a will? Larissa, talk a little bit about the importance of a will. Where does that come into play? What is it actually going to do for you, and who should actually have this?
Sure. So a will is a legal document that names an executor who will manage your estate, which is your assets and your money and whatever you leave behind of value after you die. And in your will, you name beneficiaries who will inherit your property when you die. So that includes money, real property, bank accounts, anything that you leave behind with value. So anybody over the age of 18 can legally execute a will. And a will, once you execute it, it's good for the rest of your life. It doesn't expire. But if you want to make changes, you can update it as long as you have the legal capacity to do so. So that you're in your right frame of mind, you can always update your will. So it's never too soon for a person to get a last will because they will be good for the rest of your life and they don't expire. And even people who have modest amounts of money should still get a will, because you don't know what you will have in the future. And unfortunately, some people do pass away from accidents, and money can be owed to their estate if they pass away and somebody was negligent and caused their death. Their estate can sue for money. So a person can come into money even after they're dead. So that is why a person would still want to have a will, even if they do not have much money in this time.
So obviously you work more with law, but do you have to go to a lawyer to develop this will?
No. So it's recommended to go to a lawyer because the will has to be executed according to the laws of the state that you're in. And each state has different rules on how a will needs to be executed. For example, Nevada requires that the will be in writing, that it be dated, and it has to be witnessed by 2 disinterested witnesses. But with online services, you can get wills online done, and you can fill them out. And as long as it's done properly according to the laws of that state, you do not need to have a lawyer create a will for you. You can do it yourself.
And kind of even to go a step further, I know people who have went on to like Mama Berry legal forms, or not even just that site, but there are several different just Google sites, and they've been able to take it to a bank and get it notarized to actually formalize it for. So if you do have a will, where would you suggest, or I guess the first thing after you've done this will, where would you suggest keeping that?
Okay, so if you have done your will yourself and you have done it properly and it's a valid will, You should keep your will in a very safe place. So most people keep them in a safe deposit box, or they keep it, somewhere that it's private and it can be guarded from a fire or theft or anything like that. You just keep your will with your really important papers. And the key is to let your executor, the person that you've named to manage your estate, know where that will is. Because if nobody can locate the will, the law will step in as if you did not create a will, because it has to be located for it to be valid. It has
Is there
to
a certain time frame, like after you die, or that they take? Most people, or outside the law, that it usually takes to step in.
So you're asking me if there's a time frame after you die that the will has to be produced?
Right, like shown so that the law won't step in.
Yeah, so I'm in Nevada, and I know Nevada laws. I don't know Missouri laws, or if
Right.
anybody else is watching anywhere else. But in Nevada, there's a statute that says that within 30 days of death, the original will has to be filed with the court, the clerk of the court. And so the original gets taken down to court and filed, and then the lawyers and the family will keep the copy to file with the paperwork to go through court to open up probate. And it should be noted that if you leave a will and you leave assets that are subject to probate, which is the court process of switching over the assets from a deceased person to a living person, then that process is court overseen. So that basically means a lawsuit will have to be filed on behalf of your estate to open up probate, and the court will oversee the distribution of your assets to your heirs. And before your heirs can be paid, your creditors have to be paid. So you can't just die and leave a bunch of debt and keep some money in a bank account and think that your heirs will inherit that money through court without having to pay the creditors. But there is one warning that I do need to let the watchers know, is that if you name beneficiaries on your account, or if you have a joint ownership account, then those types of transfers bypass probate. So the only assets that will go through probate court and be subject to your will are assets that are in your name alone, without a beneficiary and without a co-owner.
Well, that makes sense, because obviously a joint owner could go in, close a bank account, that type of thing. So
Yeah.
how would you tell, or what's one way that you can ensure that if you did this will without going to a lawyer, that it's not fraudulent? Because I know you said, hey, if it was properly executed. So the most states you have to execute it with the state, or execute it. How do you know if it's not fraudulent? Like somebody could avoid it.
Yeah, so most states that I know of require there to be 2 witnesses to the will. So when I have clients come in and sign wills in my office, we have 2 staff members and myself in the room when they're signing the will. And then the witnesses fill out what's called a self-proving affidavit. And it's an affidavit that gets notarized that says that those witnesses saw the person sign the will and they appeared to be of sound and disposing mind and memory, and that they were over the age of 18, and that they could read, write, and understand English. So that's a way to prevent fraud, is by having 2 witnesses witness the will. It's not enough in Nevada that a will gets notarized. It has to be witnessed by 2 people. And I'm pretty sure it's like that in most states.
So one of the things that we see, even with celebrities, with everything that's going on in our life, we've seen a lot of people pass, and a lot of people with assets pass. And usually the issue comes because they simply just didn't have a will in place or have any type of documentation. You mentioned before, but what would you say is the advantage of having a will versus, like you said, hey, if you don't have a will, or if the will is not produced in a certain amount of time, your assets, everything goes to probate. Why is that such a bad thing?
Okay, so assets, that a will goes through probate, but I think what you're asking me is, why is it bad to not have a will?
Right.
Because if you do not have a will, your assets will distribute according to state law. So the state will decide who gets your property when you die. You don't have any say over who gets what. And that produces conflict within families. And furthermore, it creates a situation where somebody that you don't like or don't know could get your money. So let's say that a mom divorces a husband and leaves behind a child, and the mom dies. Well, child would inherit mom's assets if mom did not have another spouse when she died. But let's say that the child was also deceased. Then that child's share of the mom's assets could end up with the mom's ex-husband. Because when you pass away, if you don't have a spouse, it goes to your children. If there's no will, the law says it goes to your children. And if you have no children and no spouse, it can go to your parents. So there are situations where you're going to want to get a will because you want to say who will get your property when you die. You may not want your kids to get your property, or you may not want your spouse to get your property. And you can also provide for contingencies if a person that you want to inherit your property predeceases you, so that your money doesn't go to their heirs. So it is very important that people get wills. I have a situation that I just took a case where a husband and wife got married, and they both had children from a previous marriage. And the husband died, and they didn't have wills. So the husband died, and because there were no wills, all of his assets that he acquired while he was married to this woman, which was about 30 years, would go to the woman, to the wife, and not to his children. And so then the wife dies about 2 months later, and all her assets end up going to her kids, even the assets that she inherited from her husband, who had kids from a prior marriage. So what happened in a nutshell is basically that man's assets ended up all with his wife's children from a prior marriage, and his kids didn't get any of his money by law. So I'm sure that's not the way that he would have wanted things to be. I'm sure when he passed away, he would want his kids to get some of his money and his spouse to get some of his money, or vice versa, or nobody. Like maybe he wanted to leave all his money to charity. But because he didn't have a will, his assets will now pass down to who the state picks to be in line next to inherit property. So it's not pretty when there's no will.
Yeah, and it really is about being organized. And yeah, no one likes to think about, oh, when I die. Nobody wants to think about that. But the fact is, we all have to be. That's the more responsible thing we all have to ensue. Because like you mentioned, I was just more also thinking about the situations of there are so many families where you're right. It may be like a brother's daughter is caring for his brother. They don't have no direct lineage, but that's the person he wants to. That's the person who's doing his banking, his paying all his bill, that's taking care of him medically, and then he dies, and either his brother or his sister can go get the funds and go do whatever they would like with him, and the person who he intended, which is like a niece to him or is a niece to him, that wouldn't be directly who it comes. The other thing I've seen in working in financial services down in Missouri is a little bit, some states, a lot of people can go become executive estate in a probate scenario that don't have anything to do with the scenario. They could be like a third cousin or something.
Yeah, that's happened here.
Yeah, so that's the importance of this. And like you said, if you didn't work hard and you built up some level of wealth, you got a house, you got, got a retirement, maybe you got $500,000 in assets, something of that nature. When you think about when you die, where you want that to go, obviously your first go-to, is your kids. And then if it doesn't go to your kids, I'm pretty sure you're not going to be excited about whoever it goes to, unless it's like a sibling that you done had this conversation with, that they're just aware. But 9 times out of 10, I think the will is important because, like you said, it's not just the fact of where it's going. You can also tighten the rope on, okay, even if a person want to subside themselves after I die, I can kind of keep a little bit more rein, like, hey, man, this was more intended to do these things, and this is how it should go. So So good. So the dangers with the probate, or what if you have to go to probate? What are some things that a person, or based off your state, that you've seen that someone should be prepared for?
So if a person leaves a will and it has to go through probate court because the assets were left in their name and there's no joint owner and there's no beneficiary, then probate gets open with court. And some of the problems with probate is that, number one, it's a public process. So everything filed in the case, including when you died, how you died, how much money you left, who your heirs are, is all public. And it's public as to who is going to inherit how much money. And there are predators who will look up these things online and start preying on people. The other problem with probate is that it takes a long time. It's a court overseen process, and most probates take about 6 months to a year and a half. So the beneficiaries do not get any money until the probate is over. And if somebody needed immediate access to that money, such as your spouse, then that person will have to wait until probate court is over. And one of the other problems, big problems with probate, is that if you leave money to minors, or if you don't have a will and your next of kin are minors, then that money goes through a guardianship, which is another court process, which will lock up the money for those minors until they're 18. So they cannot access any money they're left until they're 18. And then the problem with that is that they get that huge chunk of money right at 18. So if you left, let's say, $1 million behind, and you and your spouse both pass away in a horrible accident, and you leave 2 3-year-olds behind, and you don't have a will, or you do have a will, but you name your children as the beneficiaries, that money that they're supposed to inherit, they will not get until they're 18. And then once they're 18, they get that money with no oversight and no direction. So that's why a lot of lawyers do recommend trusts for people who have an appropriate estate and assets that are appropriate for having a trust. Or if they have minor children and life insurance policies, then we recommend setting up a trust, because a trust leaves more control over the money when you pass away than just a simple will.
No, so good. I'm glad you started to speak on the trust. Before hitting that, talk a little, or if you don't mind, it's not just the will for, like you said, someone who has major assets. When we think about just this past year of the lives that we lost, family members, and the financial strain that was already happening, I want you guys to think about, okay, if a parent, or if my parent passed and I didn't have an emergency fund, and that parent had $4,000 or $5,000, the average funeral is about $8,000, but they had that, and your money is already tight. You're not having a simple document in place puts a strain, because typically when somebody passes, that funeral is usually within the next week or so. And then from that point, I mean, obviously funeral places, funeral homes, and all those burials, apply, like those bills have to roll in. So, and even if you have life insurance, which is great, that's awesome, which a lot of people, we kind of miss on the life insurance and the will. But even if you have life insurance, you don't get life insurance right when the person dies. There's a process before you're looking probably at a 60, 90-day process before you even see that check. And that's way before you actually need that money. Again, especially if you're the average person who can't really foot an $8,000, $9,000 bill right away. And then that, when I talk about the financial piece, it's more that it adds a layer of pressure to the emotional piece, because you're in the midst of grieving the loss of your loved one. So the point of having this thing is, yes, does it sterilize? It's a plan. I get that, but it's so that you can have your space to grieve when that person dies. Okay, whether we want to argue, mama didn't give me this, or it doesn't really matter. This is how she wanted it. There is no question of what you can debate all you want to, but on paper, hey, she wrote this in sound mind. She had her reasons. Unfortunately, she's not here to discuss it, which I am a big fan of there is a point in time where you should have a will and you should have a discussion around it so that even if you do pass, a person understands why they're getting a certain proportion. They understand why this is going on. Will it change anything? No, but at least they don't come to the table like some of these movies be saying after, be like, he was worth $10 million. What am I getting $1,000 for? You know what I mean? Like what happened? You know what I mean? I thought it was straight. No, he knew what type of life you lived and he didn't agree with that. So that is so important about this. But that was one thing that I saw over this past year with the pandemic, seeing multiple lives lost. But then it was the fact that after that, families were scrambling. Families were really trying to make things happen. And oftentimes it's just because somebody wasn't on the accounts. Obviously, the paperwork wasn't done, but a lot of this could have been summed up with the will, because banks will accept that information. If you have a will and say you were POA on the account, well, the POA runs out, power of attorney runs out once the person dies or anything of that nature. So if you at least have the will and the death certificate, that can get you access to those funds from a banking perspective, so you don't have to wait going through court. And if this person got $10,000-$11,000, you can take care of those initial things without having to go through so much clamor. You started talking about the need for a trust. When do you think a person, from what you've seen in clients, is, hey, I need to take that next step past the will and start to look at getting a trust?
So I recommend trust for people who have children, young children, because with the trust, you can have your children have access to that money, but you can have a person oversee that money for your kids until an age that you believe that your child is able to manage money for themselves. So, for example, you can have a trust set up and then you name a trustee to manage the money for your children if you pass away. And you can set ages where your kids can inherit X amount of dollars, or they can have X amount of dollars every month to pay for their, education, maintenance, support. And I also will recommend getting a trust for people who want to avoid probate court. Because if you have your assets titled into a trust properly when you pass away, then those assets will also avoid probate court. So it provides a layer of speed, efficiency, and privacy, because people don't want all of their information public. So most of the stuff that you hear about, like celebrities leaving X amount of money or not having a will, that got to the media because it's all public in court documents. So the media will research court records and figure out, who left what, what assets they left to who, what their estate was, what's in their estate. So a trust is appropriate for a person who wants their loved ones to avoid probate, who wants privacy, and for people that want to have more control over their money when they pass away and can leave stipulations on money.
Now, I like the trust aspect, because obviously when you get deep into your finances, you do develop a sense of control freak and all this. Because I'm like, hey, I know I can control myself. I didn't work on me, but we all know, and I mean, you have kids as well, so you know, and I mean, I have friends who have kids, so I'm on my first one, and I hope this works out for. But my thing is, there are a lot of people who, when you think about your siblings, every child isn't the same. Everyone doesn't have the same sense of responsibility. Sometimes you have a child that just so happens to go off the rail. Now, you've dealt with several clients. What have you seen as far as that you would encourage? Do you think there is a time where you'd be like, hey, just release all the assets to them? Or do you be like, well, if you have an inkling that you don't think the person is going to act right, just kind of have it set up to where it's monitored like indefinitely?
Right. So to answer your question, it depends on, the capability of the individual that you want to leave the money to. So, if they're a minor, or let's say they have a drug problem, or they may have special needs or different issues that will require somebody to oversee the money, then that's a situation where a person would want to leave money in a trust long term for their beneficiary. But another scenario is depending on how much money you leave, because really wealthy people will leave money in a trust and they will leave it in trust for their kids and their grandkids, and something that will continue for many generations. But another benefit of leaving assets in a trust is that you can create what's called an asset protection trust for the beneficiaries, and that could protect the money from creditor attacks, from divorce, and from bankruptcy. So in my estate planning, I always ask my clients if they want to set up a lifetime asset protection trust for their children. And that money could stay in trust with somebody overseeing that money for their children, so that the money never gets squandered or is under attack from like a divorce or a creditor or things like that. So you can really set up trust to protect money long term.
That is, I mean, that's ultimately the biggest thing, because when you talk about generational wealth, I mean, you can trust your kids, but you're right. What if they have a nasty divorce, or what if they
get into a bad car accident, and
right? Or what if they were partying too much and, you know what I mean, just did something freak, you know what I mean, and destroy somebody's house or something. You just don't know. And so it's not to say that money isn't there to help ease some of those pains, but it would kind of be sad if you have built up this level of wealth and your child marries someone and the divorce, or they decide to separate or whatever, and it gets a little nasty. And so the person like, well, I'm finna go after your money, even though it ain't really your money, you know what I mean, your parents' money, but they're the heir to it. So I mean, those are things like you try to protect yourself as much as possible, but knowing that you have these tools in place is because the fact is we have these situations happen. And it's not to say that we don't trust their judgment. It's insurance. It's a different type of insurance, but it's more liability insurance. It's not something you buy from the insurance company, but it's basically to say, hey, if you make a decision, this is a good thing for you. This is a good thing for your family legacy, that, hey, it doesn't get, again, into the wrong hands. You have the generational part is tough. Like statistically speaking, most wealth leaves within that first generation about 70% of the time. So if you're not protecting it, a lot of wealth leaves in the first generation just because, like we just said, they just don't have a will, they don't have anything in place. And so if you unmask a certain amount of wealth, and with the internet being what it is, people just all day, who died? Let me see what they got. Oh, I finally found a good one. And then they go do the work that the average person isn't going to know. Oh, let me go to the court and see what I need to do to get these assets. And then on top of that, if we never talk about money and we never know what the person actually has, no one would ever, they'll just naturally think, oh, they don't have anything. But what if they had $200,000-$300,000? Well, that's
a good point. That's a good point. People do need to leave inventories of their assets. So if you pass away and nobody claims your money, or they don't know where your money is, what happens is it ends up in the state treasury department in unclaimed property. And currently there are billions of dollars sitting in state unclaimed property departments. So yeah, somebody could leave behind, $1 million. And if their heirs or their family or loved ones don't even know about it, then they'll never get it, because you have to have a record of where these assets are. So when I do my estate plans, I also include inventories for my clients and tell them to update their inventories. And, every 3 years, you should be looking at your estate plan to see if something has changed, like a divorce, the birth or death of a loved one, and basically just staying on top of the estate plan, because you want it to work for you in the times that you most need it.
And she brought up a good point, you all. So when you're reviewing these things, so yeah, when you get married, you definitely, if you haven't already, you want to have a will. If you're not married, you definitely just want to go get a will for the things that you have. Name someone. When you get married, that's a life event change, is what we call it in banking terms. So if you get married, you open a business, you buy a house, you have a kid, those are all someone unfortunately passes. Those are all major life events. And every time you do a life event, that's when you want to reevaluate, to Larissa's point, the estate plan. What's your will? What's your trust? Now, if I understand correctly, from leveling up from a will to a trust, you want to do it in the fact of once you have probably that first kid. So, am I following correctly? Just please stop me. Yeah. So you want.
So if you, for most people, yes. If when you have a child, you want to start thinking about maybe a trust, because if you've bought life insurance, you don't want to leave that money directly to the child, because they won't be able to access it till they're 18, and then they'll get all the money at 18. And I see a huge mistake people do, and I can't even believe they do it. But what they do is they'll name a beneficiary on their life insurance and say that person will get the money, but they'll get it to take care of my kids. That is not what you do. You never name another person as the beneficiary unless you want them to keep that money.
Exactly.
Because number one, they could be dishonest. And let's say they're not dishonest, but they do get all your money from life insurance. Once that money goes into their name, they are subject to attacks from creditors, divorce, medical bills, or if they pass away, then that money goes to their heirs. Mm-hmm. So you never will name a person on your life insurance or any beneficiary designation unless you know you want them to keep that money. Right. If you want money to go for the benefit of other people, but you want another person to manage it, then you set up a trust. And trusts are significantly more in cost than getting a will. Mm-hmm. So some people are discouraged from getting a trust. Those prices typically range, depending on where you live, from, let's say, $1,000 for the cheapest to like $8,000 to $10,000 for the most complex and complicated and in a tax planning trust with like asset protection and things like that. Right. The mid-range is about, you could expect to pay $2,000 to $3,000, and you'll get your ancillary estate planning documents with your trust. And it is a big amount of money to pay up front for something that you feel like you don't get any benefit from right away. Mm-hmm. But that is something that the money is well spent, because we spend money on vacations, we spend money on luxury cars. You need to pay to get your affairs in order for your family. If you have loved ones, then you pay the money to make sure that your loved ones will be okay if something happens to you. And that won't always be a trust. That might be a will for some people. Mm-hmm. And a will you can do yourself, or in most states you can get a will done by an attorney for under $500. So the costs vary significantly, and it depends on, what your goals are and what you want to accomplish. But getting these documents in order is a must. If you have loved ones and if you have minor children, then you will want to get some estate planning done. And it is recommended to see an attorney, even though you can do these documents on your own. An attorney will make sure that they're done properly so that they will work when you need them to work.
No, the biggest thing I think people miss in the trust, and I see them all the time because I work with a lot of clients where their homes are titled in the trust. Yeah. And the biggest thing that people miss, like the trust, the more you grow your wealth, the more complex from a paperwork standpoint, from pretty much everything financial and protecting its standpoint. You might look at your tax return now and be like, oh man, tax return 12, 13 pages. Let you get a house paid for, a couple properties, a couple $100,000 in assets. That 12 pages will easily go to 50 some pages for just a tax return. Yeah. When she's talking about the complexity of a trust, when you start to grow your assets, what I've seen is, and from people's trust, well, then you're starting to talk about all the what ifs that could happen. And you're saying, basically, you're trying to make every decision yourself without your family having to be in the emotional strain of maybe you're in the hospital and it's coming down and doctor's like, hey, do you want us to keep going? Or do you not want us to keep going? If it's this issue, if it's a brain issue, do you want us to operate or do you want us to pull the plug? If it's a, saying they come up with all these different scenarios. But to your point, if you got even $100,000 or more, $8,000 to $10,000, 10% of that, to protect it for the long term is worth the investment. It's a lot of work, definitely a lot of man hours, but okay, I know it's pretty iron tight for someone who's trying to commit fraud. They can't do it. And then on the other side of, hey, my family, I don't have there's not any confusion about what what's supposed to happen when I die. There's not any confusion about what I have. The people who I've had conversations with, maybe you don't want to tell everybody. Maybe you just want to tell the people you are leaving something to. That's fine. They know what they're supposed to do. They have their instructions.
And they're legally binding.
It's legally binding. So even if you have multiple kids, but you left it all to one and you're like, hey, I'm entrusted you to do X, or again, you don't necessarily trust them to deliberate like you want to, well, then you got the trust or the executive of the trust to be like, okay, well, your mom set it up like this. Hey, she got 300,000. You're supposed to get 100. You're supposed to get 100. You're going to get 100, but you can only get yours over this period of time because of X. So that's how it can go, but no one can argue that point. You know what I mean? I mean, they could, but it would be kind of a waste of time. But at least it ensures.
Just to your point too, like the trusts that are on the higher end of, 5,000, those are for people who have millions and millions that are above the estate tax exemption. So we're talking about people who have over $11 million. For a person, let's say, that has under $11 million and they don't have any type of estate tax issues, federal estate tax issues, and let's say they just have a home, they have money in some accounts, and they have insurance, most times those trusts are going to be under $3,000. And that comes with your will, your power of attorney, your healthcare directive, and it also that's a price, if you have a spouse, so double documents for an individual and their spouse. So it is affordable. It's what you would spend on a vacation.
Right. And then, like you said, a lot of people don't miss, because there's a couple different ways you write the will, especially if you're married. You write it, what if I die? What if she dies? What if both of us die? Yeah. So it's all those scenarios have to come into play. But again, guys, this is to protect your legacy after you built it. And like I said, you may not be the point of you got a couple $100,000. Maybe you just got an emergency fund. Maybe you just got $10,000, $11,000. So as hard as it was for you to save that money, would that be great for you to, okay, I died and that money's just locked up in court, and after a while, if it doesn't get feed to death or stolen through fraud, it's just lost. Right. So you just gave it to the state or whoever, you know what I mean?
Right. Or if you have kids, I want that money to go to my kids. I want to make sure that the kids have the money, that, they have education, or they have, after I die, I want to make sure that they're taken care of. That's, as parents, that's our number one concern, is that our kids will always be taken care of. And unfortunately, life happens, and parents can pass away before the point that they know that their children are independent and self-reliant. So I think for people to pre-plan and know that if you get a will done now, it will not hasten your death. You are just planning for something in the future, to make decisions while you're in a sound state of mind, and that will be good until you die. So I got my will and trust done, and I'm in my 30s. Right. Obviously, I do this for a living, but I do recognize that my life is precious, and I could pass away at any moment. I could be in a car accident. Right. I could be, in an act of violence, and I want to make sure that what I do have goes to my children, and I know that they're taken care of.
Yeah, it's so good. So tell us a little bit about, and I definitely appreciate your time here. Tell us a little bit about resources to at least, I know we kind of did more of a hybrid version of this information, but where would you point someone if they were trying to get a better grasp and clarity on will, trust, or even just why am I getting a will? What do I need to include in a will? What are things I need to prepare?
So on my website, I have articles, and the website is www.lesstovall.com, and that is the website for the law firm that I work at. It's not my personal website, and that's lesstovall.com. And there's a tab on the homepage that says estate planning, and they can browse the estate planning tab, and there's information about wills, trusts, power of attorney, and estate planning frequently asked questions. And under our blogs tab, I have articles about naming guardians for your minor children if something were to happen to you, what happens to your assets when you die, and different aspects about estate planning and probate. So that's a good resource for people to check out, is the website. They can also check out websites for their local legal aid, because estate planning and probate is a hot area, and local legal aid centers may have some information online about wills. There are also national websites that are good for information, like nolo.com, which is NOLO.com, and justicia.com, which is JUSTICIA.com. And I think LegalZoom also has information about wills and trusts. So those are national sites that you can look at and get resources about estate planning, getting a will. And another thing that people are going to want to do while they think about estate planning is review their accounts and review who their beneficiary designations are. So then people you name to inherit your accounts when you pass away. You want to make sure you don't have an ex on there, or somebody, people do it, people forget.
And they forget, yeah.
Husband will inherit all the money. So you want to check your accounts. You want to check your life insurance. You want to make sure you don't have any minors on there. And you want to make sure it's the people that you want to inherit your money when you pass away. And if you do have minor children that you want to have inherit money when you pass away, you may want to think about setting up a trust, and you can set up an appointment with a local estate planning attorney. And most do offer free consultation. So in St. Louis, I know of a local estate planning attorney there. I went to law school in St. Louis, and one of my good friends from law school, she does estate planning. And her name is Azra Ahmad. And I believe the name of her law firm is Mid-America Estate Planning. But her name is Azra Ahmad, A-Z-R-A, and the last name is A-H-M-A-D. So you could Google her in St. Louis, and she does estate planning, and she's very bright, and I would have my faith in recommending people speak to her. So yeah, it's something that we do need to think about. It's something we don't want to think about. We don't want to think about if we die. We don't want to think about what will happen if we're in a horrible accident and we're incapacitated. But what's worse is thinking about if those things happen and you don't have a proper plan in place. So you want to have your proper planning, your proper legal planning, your proper documents, so that when those things, if they happen, if you become incapacitated and when you do pass away, everything is in order for your family and your loved ones.
No, so good. Guys, if you stuck with us this far, and I definitely appreciate you, make sure if you're on YouTube, drop a comment, let me know you're here. Like all those different links. I'm gonna have her send me her information so I can make sure that's down in the description below. If you're in the Money Talks group, I'm gonna have her send me her information of the stuff that I don't have, and I'll make sure I get that posted for you all too, so you can revisit this information there. But I guarantee you, like I said, I've read several of the articles on their site, and it's very like for me, I'm not even excited about a will just in general. It's not one of the things that's favored, but it made a lot of sense, and it's very simple. And it may seem like a long read, but you actually do read it through very, very quickly because of how easily digestible it is. So I would encourage you when you're trying to digest these more difficult and complex subjects, having content that's easily digestible is helpful. One thing I would say, I know you kind of kind of glanced over it a little bit, and we touched on it a little bit throughout the conversation. But I would encourage you, or ask Larissa, if you could, before you go, what was the thing that really that you've seen throughout your career that really stressed the importance of getting this in place? I know for me, like I said, being in the banks and seeing how difficult it was and seeing people in a state of grief, like there's nothing like that. And even as much as I didn't like it, as much as I don't like talking about wills and talking about death, the fact is to see that pain and see that struggle, or to see the arguments, the conflict of people, and or having to tell someone who they just lost a spouse that they can't access whatever dollars in the account because, you know what I mean, the person died and it doesn't follow procedure at a time where they didn't lost them is extremely difficult.
Yeah.
It's too difficult. Personally speaking, I remember a young lady, she was married. I spoke to her and her husband. She was there like a Wednesday. The next week, she came in. She was like, "Oh, he passed." I'm like, "Oh, he passed." So I agree with you, all those different things. She went to try to get money for her bills like she normally do. Wasn't able to do it because he's passed right now, and she's not really on her account. She's not knowing that every time she came to the bank, because he was with her, that's why we were giving her the money. Now he's gone and he's dead, and they banks through your social, they're notified that you're dead. So while you're in the hospital, the Social Security system already notified them, hey, this person is deceased. And once they get a deceased notification, all accounts are frozen until we can get the proper documentation to release. But I would, if you could share something that you've seen, not to scare, but just to stress the importance of doing this step in your financial responsibility.
Yeah, so I do probate work. So when people do pass away, I help with transferring the assets through court to the living heirs. And I also do trust administration. So if you get a trust, then it doesn't go through probate court, but sometimes people hire lawyers to help them handle the money and the reporting. But one of the stories was a woman was engaged to a gentleman. She came in, he had passed away. They were engaged, and they didn't get married. They were supposed to get married in a few weeks. They were an older couple, probably in their 60s, and he had a lot of money, and he didn't put her on any of the bank accounts or the beneficiary designation on the life insurance. And his niece inherited all his money because he was not married to this woman. They were engaged, and she had no legal rights to him. And they were together for a long time. I don't remember how many years it was. But had he have had a will, he could have made it that she would inherit the money that he left, because that probably would have been his wish. They were together and they were engaged to get married. And a distant niece inherited a couple $100,000 of this guy's money. And when I saw that, I thought, there are a lot of people who are in relationships. They've been together forever, and for whatever reason, they don't get married, and that's their business, no judgment. But if you're in that situation and your partner dies and they don't have a will, you have no legal rights to their money or their property. Mm-hmm. Even if in Nevada, we don't have common law marriage. So even if you've lived together for 20 years, had 5 kids, if you are not married, you have no rights to a person's property. So that let me know, hey, these couples that are together that have not gotten married, they need to have wills. Mm-hmm. If they want their partner to inherit the money, because they won't. The state law does not provide for that. And also, situations where people are married and let's say they're estranged, but they never got legally divorced and there's no will, then their spouse that they're estranged from can legally inherit the money. Exactly. So there's a lot of situations out there. Life happens. We don't know how things will turn out. So to make sure things turn out the way that you want them to turn out, you get the proper legal planning done.
So good. So good. I hope you guys enjoyed this. I definitely had a lot more fun and learned a lot. Very, very rarely do I come with so much more knowledge from a video, but it's so important to get this step done. And if nothing we've went through a lot of pain over the last couple of years, but especially this last year and still going through it. But it's more stressing to the point that, hey guys, we have to take the responsibility, even if we're the first one to do it, which a lot of times, if you're talking about money and talking about wills, you're probably the first one in your family to discuss this and bring this to your family. If you still have your parents, they need to get a will too. It's not just you. Like, everybody needs a will. So maybe this is something you guys sit down and do all together, but it needs to be done, because what will happen is the opposite will be true, meaning once the state comes over, when the state takes over anything, it's never really a joyful experience. So, so guys, we definitely enjoyed you. I definitely appreciate you being here, and I can't wait to see you guys in the next video.
Thank you.